obviously the government has taken the first step forward by saying that the government is going to constitute a committee chaired by the cabinet secretary. Second, but even more fundamental, in some ways, and not so fundamental because ultimately it has to see progress on the ground, which is how do you define and how do you give meaning to the content of constitutional values? So even assuming that we accept your submission on the legitimacy of marriage as a social institution, the stability of the order, the legitimate interest of the state in protecting the concept of marriage as a heterosexual relationship, or deciding to what extent you will also dilute that concept, it's a matter for the state's legitimate interest and parliament to regulate. Equally, there is, even in this area that we are debating, some element of constitutional jurisprudence left for the court to evolve.
Look, with great respects, the court will not be issuing a declaration which is amorphous, vague. Some sort of recognition needs to be given. I mean, a declaration emanating from the lordships has to be concrete and definite, which results in something positive straight away in their favor.
Are we in a society, a constitutional society, and we are now approaching our 75th anniversary? Are we in a state where we say that a declaration by the state, by one of the co-equal wings, which is tasked with interpreting the constitution? I am not saying exclusively, because other wings also are entitled to. When it says that this is it, and beyond that it will not say, it cannot say, because it cannot implement it.
And we are conscious of the fact that we cannot tread into the legislative domain.
So once we say that, does it not have its own force? Are we trained? Let me complete. Let me just complete. Is common law seeped into our bones to this extent that everything that we say needs to be executed through contempt or through some execution proceeding? Is it not sufficient that the court says that this is the state of affairs, and that's out there for the people, for the parliament, and other branches of governance, including constitutional branches of governance? And I'm not talking of only the constitutionally recognized branches of governance, the society at large, that this is the state of affairs. How it is assimilated is not up to us.
I'm certainly not saying that lordship's jurisdictions to make an appropriate declaration is not there. That's not
taking it beyond the writ of mandamus. I'm just taking it.
What I'm requesting and beseeching your lordship is that please do not issue a amorphous, vague, too general a declaration which has no meaning.
But take the case of privacy, right? We located privacy in constitutional precepts, but we were conscious of the fact that if we have to implement privacy in the concept of, say, informational privacy or data privacy, we can't do it ourselves. It has to have a legislative backing, and therefore we left it to Parliament to legislate. But Mr. Dwivedi, the very act of the court having granted a certain degree of legitimacy, constitutional legitimacy to privacy, has a very vital role to play in society.
No, but that was not a general exercise because the lordships had an Aadhaar Act in front.
No. When it came to the 9 judges, there was no Aadhaar.
It was independent.
It was argued. You are aware.
9 judges reference came from that only.
Correct, maybe, but then it was an abstract reference.
Because Mr. Rohatgi argued that there is no right to privacy.
The only question was privacy is there or not.
But then it's a wider concept now. There is no law.
Even 9 judges' judgment did not involve any declaration for the purposes of Parliament to do something.
All right, I'll go back. What did 11 judges do? 11 judges did not have a statute before them. Now, Mr. Sibal is there.
No, they didn't.
There is no statute which has been invalidated. There was no statutory model.
No, it was a reference in a pending proceeding. With great respect, certain questions are everyday referred.
So what is the content of 30? Mr. Dwivedi also argued. We all know that. It was only argued what is the content of 30. It was in the abstract.
No.
Why you're finding it difficult? What we are talking about, both Chief Justice and Justice Budd is talking about, if there is a right It's a recognition of a right. The order of a court is in the context of recognizing the existence of a right. It's thereafter for the legislature. Court might not be able to do or take up any executive action to implementing it.
So
Once there is a recognition and court stops there, it is thereafter for the executive
that's
to take it
precisely
up.
where I'm, my lord,
And it's
engaging
one of
in-
the most important and
No, I appreciate, my lord,
function
but
of
this
a court
is
to give a
precisely where I'm
recognition.
engaging in this debate, my lord, is that when it comes to recognition of a right, then this is a sphere. What sort of recognition your lordships will be providing?
Absolutely, you're right.
That's the
Now, let me just state 10
That's
points. my lord.
exactly what we are also deliberating on.
matter.
We are sort of introspecting at this stage. We are now almost towards this last third of the arguments. That's why we sort
So
of,
in fact, that's one of
we are
the
also in a
core
state
functions
of
the court.
mental
No, I appreciate.
churning.
No, it's important, my lord, for such debates to happen.